Eviction is the legal process of removing a tenant and their possessions from their rental unit in a residential property. There are many valid reasons for eviction, but landlords need to follow their county and state-specific laws throughout the process. There are 6 steps to completing an eviction, which we'll go over in more detail. Try to solve the problem amicably. Send an eviction notice, file eviction papers, attend a court hearing, obtain a judgment, and collect past due rent. At the end of this video, we'll also briefly discuss eviction timelines. Before we start, make sure to grab your template for a notice to quit at the link below. And don't forget to hit that subscribe button for more videos by eForms, the world's largest database of official legal documents. Step 1. Try to solve the problem amicably. Before initiating eviction proceedings, landlords need to try at least to resolve the lease infraction directly with their tenants. This attempt is good for landlord-tenant relationships and can resolve many lease violations. It also might save landlords a lot of money in the long run, as evictions have the potential to cost thousands of dollars. Step 2. Send an eviction notice. If a tenant refuses to cooperate with their landlord and state laws, it is time for the landlord to send them a formal eviction notice. An eviction notice, also known as a notice to quit, notifies a tenant of a lease violation and the potential consequences of ignoring the notice. A curable notice gives the tenant a specific time frame to fix the violation or vacate the premises with their belongings. An incurable notice does not give the tenant an option to fix their lease violation. They will receive a deadline to vacate the premises. There are 4 standard types of eviction notices. Notice to pay or vacate. Non-payment of rent is the most common reason for evictions. This document is given to the tenant when they have failed to pay rent by the due date. Some states have required grace periods that landlords must honor before sending notices to tenants. Notice to comply or vacate. A landlord uses this notice when a tenant has breached any clause of their lease agreement other than non-payment of rent. Illegal activity. This notice terminates the lease immediately because the landlord has evidence that the tenant engaged in unlawful activity on the premises. Month-to-month termination letter. Both landlords and tenants can issue this notice to the other to end an at-will tenancy. Landlords can send eviction notices to tenants by any of the following methods: certified mail, hand delivery, post in a conspicuous place on the property, and standard mail. Usually, standard mail is not recommended because there is no way to track or affirm that the notice got to the tenant. Remember, you can't evict someone for just anything. Click links below for state laws and timelines for state-specific evictions. Step 3. File eviction papers. If the tenant doesn't fix the violation or vacate the property within the time frame allotted, then the landlord can initiate formal eviction proceedings with their local county court. Every county and state has varying required documents for this process, but generally landlords will need the following information: the full address of the property in question, a copy of the eviction notice, a copy of the original lease agreement, a confirmation or receipt of delivery for the eviction notice, a description of the reason for requesting eviction, if applicable, an accounting of all unpaid rent still overdue at the time of filing, and if appropriate, a statement of attorney fees being sought after. Step 4. Attend a court hearing. When the filing has been processed, the court usually issues a summons that orders the landlord and tenant to attend a court hearing on a specified date. The landlord should bring copies of all filing documents to the hearing. The tenant should bring any evidence of rent payments, violation fixes, or lease agreement breaches made by the landlord. Step 5. Obtain a judgment. If the judgment favors the tenant, the case ends. If the judgment favors the landlord, the court will give the tenant a specified amount of time to vacate the property. Sometimes the tenant doesn't move out by the court-mandated deadline. In this case, the landlord can request a writ of possession from the court to authorize local authorities to forcibly remove the tenant and their belongings from the property. Step 6. Collect past due rent. Often the winning party is entitled to recover all of their court costs from the other party. If the tenant's security deposit doesn't cover a landlord's losses, they have to file a separate claim against the tenant in small claims court. But how long does this whole process take? From sending the eviction notice to obtaining a court judgment, it usually takes a few weeks to 6 months, depending on how court proceedings unfold. And how long does an eviction stay on a person's record? An eviction stays in the public record for 7 years. It is not stated on a credit report, but does appear on consumer reports. So where can you find legal documents online? If you need a notice to quit, a demand letter, rent balance letter, lease amendment, or any other form, we have thousands of state-specific ready-to-go templates available for you to download with no membership or credit card required.